Good morning, you're Tarini Thomas. Tarini, and Ms. Thomas was placed on, well, first, this is cause number 13, 18010. Ms. Thomas was placed on probation back in April of 2016. It was a 5-year deferred probation for the third-degree felony offense of forgery of a financial instrument, and a motion to revoke was filed October 25th of 2018. Ms. Thomas was arrested, it looks like back in July of this year, pled true to counts 1, 2, and 3, which is failure to report, community service, and behind in the fees, obviously. And so I've received the updated report. Has everyone had an opportunity to review the report? Are there any additions or corrections to that updated report?
Not to mistake.
Is there any, as from, I don't have a choice here, correct? I mean, I have to revoke.
Yes.
Okay, Mr. Samuel?
Your Honor,
Argument?
after visiting with Ms. Thomas, and I've known the family for a long time, this just snowballed out of fear. Once she could not find a job, she finally found a job over in Houston, in Humboldt, and she was going to try to make payment, get the money to make payments to get right, and it just snowballed from there. So she's at the mercy of the court. She takes full responsibility for what has happened. The only thing she would, one of the things that we discussed and she mentioned, she would like to make whole by taking care of the financial responsibility, in hopes that at least that would give the court an opportunity to consider the minimum sentence. And with that, she would be asking that this be held in abeyance for her to work to get this payment. And she believes she can get that within 30 days and come back and ask for the minimum sentence.
She absconded for 7 years.
We understand.
Yeah, I mean, I can't, I don't feel like that is an appropriate option to let her back out of jail to pay something that she had 7 years or more to pay. That's not going to happen. I respect the ask on that, but when you've absconded since 2018, for me to say, yeah, go back out for 30 days and think we'll see her again is not.
Well, I understand, Your Honor, and I understand the hesitancy by the court, but we all fall short at times and make bad decisions.
No, I don't disagree. I don't disagree, and I'm not looking at the max either. I'm not going to let her out. She could have paid that for a long time. We're not going to hold anything in abeyance. Whatever's going to happen is going to happen today.
Well, we ask that she be given 3 years.
All right, thank you, Mr. Samuel. Mr. Smith.
Judge, it's capital 5. I think that was the greatest gift she could have been given. So we're asking for 5.
So, Ms. Thomas, the thing is, I mean, you have zero criminal history. This is your only case, and such a great opportunity was given to you 12 years ago? No, 8. Anyway, long time.
Yes.
And you had all the opportunity to get this taken care of at any point in the last 8 years. I don't know that I understand Mr. Smith's position. I understand probation's position. It's very frustrating when you're given an opportunity and you just ignore it like you did. I also don't know that if we were to sentence you to prison today without any probation, that 5 would probably not be what was the offer. But I get the position. I'm going to, at this time, find that you entered your pleas for true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of forgery of a financial instrument. I'm going to sentence you to a term of 3 years of the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Samuel. Good luck to ma'am. Thank you, and thank you for being here, ma'am. See, is there a Mr. Salinas here? Mr. Salinas? Mr. Hoffpower, have you spoken with him?
I spoke with him 2 weeks ago.
Okay.
About having, I've got a courthouse here.
I'm sorry?
I've got a video here for him to review with his client.
Oh, okay.
About discovery.
Gotcha. Okay.
I was spoken.
Can y'all check on him? Thanks. Let's see. Ms. Holmes, you've got Robert Davis. It's a competency.
Robert Davis.
Good morning.
Good morning. How are y'all?
Good. How are you? See? No. He came back from John Dunn, so now I've got to send him for the year. He went for the 120. I think that's what this is. Yeah.
Gotcha.
Good morning. Are you Robert Davis?
Yes, ma'am.
This is 24 DCCR 1020. Mr. Davis is charged with obstruction or retaliation, was previously found not competent to stand trial, and sent to the John Dunn Behavioral Science Center for competency restoration for a period of not to exceed 120 days. We've received the report from John Dunn Behavioral Center, and that's dated October 15th of 2025. And along with that packet, there is the chronology and what was done there with regard to competency restoration attempts. The finding by Madeline Gabe, Dr. Madeline Gabe, is that he is currently not competent to stand trial, and an extended civil outpatient commitment is being recommended. In addition to that, we received a report of competency to stand trial evaluation, and that was issued by the examiner, was Dr. Cassandra Hayes. It is also her opinion that Mr. Davis is not competent to stand trial, and that further treatment for competency restoration under a civil commitment would be appropriate. And we also received a physician certificate of medical examination for mental illness from Dr. Stocks. So this finding is that Mr. Davis does not meet all of the criteria for inpatient commitment, but does for outpatient commitment. The finding is that he is mentally ill, that mental illness is severe and persistent, and as a result of that, if not treated, would experience deterioration and further issues. That's dated October 15th of 2025. There is a second physician certificate of medical examination for mental illness from Dr. Gabe. Her finding is the same in that the recommendation is for outpatient commitment, and the same finding of mental illness being severe and persistent, and that as a result of that, if not treated, would experience deterioration of the ability to function independently. Other than that we've received, is there any other evidence with regard to competency?
No, Your Honor.
And so, obviously, for the record, we do not have here in Jefferson County an outpatient competency restoration program. And so based on that, if there's no other evidence, I am going to take judicial notice of all of this in the court's file, find that Mr. Davis is currently not competent to stand trial, find that he is mentally ill, and that as a result of that, if not treated, would experience deterioration of the ability to function independently to the extent that he would be unable to live safely in the community, and find that based on the fact that we do not have an outpatient competency restoration program, I am going to find that inpatient treatment is required because of that, and order inpatient treatment for a period of not to exceed 1 year as a civil commitment. Obviously, if we receive notification that competency has been achieved before then, we'll get Mr. Davis back here immediately and go forward with this case at that time. All right, you can go back with the bailiff. See Tracy Davis, Ms. Holmes.